Stakes are high in the Sunshine State as the state Supreme Court considers if Floridians should get to vote on a new state law guaranteeing access to abortion.
It's one of several states where abortion could be on the ballot this November. CBN Washington correspondent Hilary Powell has been following the case. Hilary, how will this affect Florida families?
Well, John, Jenna, the future of abortion access really comes down to wording. Supporters want to preserve a state constitutional right to abortion, while critics see it as a total deregulation of the procedure. Now, before voters even see a ballot measure, the state Supreme Court justices must approve the wording, and both sides are weighing in on the issue.
Is this hiding a ball in some meaningful way, or should we not say, the voters can look at this and say, gee, that sounds really sweeping, let's not approve this?
Here's the current language. No law shall prohibit, penalize, delay, or restrict abortion before viability or when necessary to protect the patient's health, as determined by the patient's health care provider. This amendment does not change the legislature's constitutional authority to require notification to a parent or guardian before a minor has an abortion. The Florida Attorney General wants the court to reject that version, saying the word viability is unclear.
The language of the amendment itself is of such elasticity that an enormously wide range of meanings will attach to it, and voters will not actually understand what they're voting for.
A 15-week ban on abortion currently exists in the state. The group Floridians Protecting Freedom collected 1 million signatures to get the measure protecting abortion access on the ballot. This fight is reflective of a nationwide push for states to decide the issue. Since the Supreme Court overturned Roe v. Wade, 7 states have voted in favor of abortion access, including conservative-leaning states like Kansas, Kentucky, and most recently, Ohio. Matt Staver with Florida Voters Against Extremism says the proposal's words have real-world impact.
It is a devastating amendment that they're looking at here. It is exceptionally broad and very, very dangerous, not only to children and families, but to all of Floridians and certainly all of society, because this would create Florida as not just a vacation destination, but an abortion destination.
GOP Governor Ron DeSantis has appointed 5 of the 7 justices, as well as Attorney General Ashley Moody. Now, justices previously held Article 1, Section 23 of the state constitution already protects access to abortion, although a law signed by DeSantis would outlaw abortion after 15 weeks. Guys.
All right, CBN correspondent Hilary Powell. Thank you, Hilary. Well, Kelsey Pritchard is the Director of State Public Affairs for Susan B. Anthony Pro-Life America. Kelsey, welcome to you. So the pro-life movement for decades has said the abortion battle belongs in the states. A state constitutional amendment initiative would put that fight to Florida voters. Putting you on the spot a little bit here, Kelsey, but why do you think the measure isn't the right move?
Well, the Florida measure is very similar to what we've seen in states like Ohio and Michigan, in that it allows abortion in all 9 months of pregnancy. It also takes away parental rights, and it puts at stake women's health and safety protections and any regulation on the abortion industry right now. And in Florida specifically, this is not an industry that we want to go unregulated, because we saw a Sarasota, Florida facility that was shut down last year because so many women ended up in the hospital from that facility. And in inspections last year, 25% of those in the industry failed their inspection. So very dangerous. And even those who are on the pro-choice side really need to consider about the implications of this measure to women and parents, as well as to the unborn child.
Kelsey, since the Supreme Court overturned Roe v. Wade, what has marked the biggest change in the work for pro-life organizations like yours?
Yeah, the Dobbs decision has allowed us to actually make changes in the states. And we're not even 2 years out from that decision. And we now have 24 states across the nation that have laws protecting life at 12 weeks or sooner. So that is a huge gain. That's incredible momentum. We have data that shows that the birth rates in a lot of those states with pro-life laws have increased. So we have more babies being born in those states. And also the Dobbs decision has allowed for the federal government as well to be able to make policy on abortion and to protect lives. And so we are very adamant that we need a national defender of life in the White House, and that we need to elect more pro-life senators and Congress members so that we can at least protect babies at the point that they feel pain across this country. And that's because babies in California matters just as much as the babies in Texas and South Dakota.
Kelsey, does your group support a federal ban on abortion?
We support a federal protection, a federal minimum protection that is in line with public sentiment. And we see poll after poll that shows that 2/3 of Americans support limiting abortion in the second and third trimesters. So after that first trimester mark, people do want the baby protected. Even people who consider themselves pro-choice want protections at the second and third trimester. And so while we believe that life begins at conception, we believe we need to start somewhere, and we need to meet the people where they're at. And this is where public opinion is. And so we are very supportive of a federal minimum protection at 15 weeks, which is the point when a baby can feel pain.
All right, Kelsey Pritchard with the Susan B. Anthony Pro-Life America. Thank you so much for being with us tonight.